the SENZO MEYIWA murder trial in the North Gauteng High Court. And for more analysis on this, we're now joined by legal expert NTHABISEng DUBAZANA from DUBAZANA Attorneys, and she joins us via our telephone line. NTHABISEng, thank you so much once again for your time this evening. Of course, asking you a bit earlier on when it comes to your reaction to the judgment by the North Gauteng High Court, and you said that you are really not shocked.
Yes, I am not shocked based on the manner on which the presiding officer was conducting the trial within the trial, the kinds of interjections and the kinds of comments that were thrown in the mix. I think for me personally, it has been a theme throughout the entire trial in the manner in which the presiding officer tends to act as if they are a prosecutor within the matter and neglecting to be neutral in the matter. Of course, I may be biased in my observation and somebody else may see it in a different way, but I'm not shocked really at the fact that the confession was deducted to be admissible in the main trial.
And what would you say informed the judge's decision to come to that conclusion?
I'm actually not very sure, considering the kinds of questions that were put to the various witnesses for this trial within the trial in terms of how this confession was conducted. The requirements that are set out in Section 217 and Section 218 and also Section 219 of the Criminal Procedure Act are very clear in the manner in which it's supposed to be done. And from what you can gather, one of the accused persons, it was informed I don't even remember when, but one of the witnesses confirmed that the accused person terminated mandate with his attorney, and therefore when the confession was reduced to writing, he did not understand what had happened because it wasn't explained to him thoroughly. And yet here we are having a confession being admitted into evidence with such commentary or such evidence that has been led. So I suppose with everything that has happened, the presiding officer deems that the requirements have been met, that the accused persons were in their silence with the senses, they were not forced to make this confession or the pointing out, and as such, the confession can now be admitted in the main trial.
And NTHABISEng, we've seen so many delays when it comes to this specific case, and one would also ask that can the accused actually challenge this outcome, and what grounds do they have should they look at actually challenging the outcomes of today's judgment?
They can challenge it, but it's going to be challenged at the end of the trial because this was a preliminary inquiry. So the main trial is not over and done with. So in other words, it was just a sidestep. Maybe if I put it this way, the way in which the witnesses in the state case right now, because the state case is still open, when witnesses come to the box and they're not being cross-examined, the defense attorneys do what we call a laying of basis when they want to use the statements that were made by the witnesses to contradict whatever the witness has been saying in court on that particular day. So instead of doing it the way in which defense attorneys do it by laying basis for about 5 minutes and then continue with cross-examination, for the accused person, it has to go through the stringent requirements that we've seen in the past 5 months. And if the court accepts that quote-unquote the laying of basis for that confession to be admitted, then the table can be turned. In other words, when the accused persons now go into the box and give their evidence, their confession is going to be used against them also in cross-examination by the state.
And what does this mean also in a nutshell, especially now for the accused? This is evidence that they don't want to see in court.
Well, at this stage, there's nothing much they can do. It's just now the witnesses that were giving evidence in the manner in which the statement or the confession was made are now going to give us the merits of the statement, which are going to relate to the actual case that we need to be dealing with. So at this stage, the only thing that the accused persons can do is sit and watch. We'll only know the probative value or the weight in which the court is going to give these statements at the end of the trial when judgment is handed down. And if the judge decides that the confessions have a heavy or a strong weight or what we call probative value, then in that instance, the defense attorneys will then have the opportunity, once judgment has been handed down and sentenced, then they can make an appeal or a review application at the end.
And lastly, for the trial, which is now set to get underway, with this the evidence, what would it mean then for the actual trial going forward?
So now, hopefully, we're not going to encounter any more detours going forward. So now it's just a matter of basically continuing where we stopped 5 months ago. If that witness, I don't even remember if that witness was done giving evidence at the time. If that witness was done, then we continue to the next witness that the state is going to call, particularly the witnesses that are going to now confirm the contents of those confessions. And then obviously we continue in the same manner wherein the defense attorneys will then cross-examine the witnesses. But the thing that we need to be mindful of is that the evidence that was adduced within a trial is not going to be used in the main trial. So the defense attorneys can't say, no, but wait, in the trial within a trial you said, but now you are saying this. So it will be as if the trial within a trial never really happened. We are now focusing on the merits of the matter.
All right, NTHABISENG, thank you.
The so-called alleged confessions or statements of accused number 1 and 2, and the pointing out by accused number 2, the defense objected. And the principal objection was that, 1, they did not make statements. They did not make confessions. They were told to sign documents which were fully completed, and they were told sign here, sign there, initial here, initial there. That was the initial defense. The second defense is that they were assaulted, tortured, severely, as Mr. Mgomezulu put it, severely tortured, choked, electrocuted, kicked, in order to elicit their signatures on the documents. In other words, these accused before court, their evidence is they don't know the contents of the confessions. They don't know. They were never read to them. And if you go further, accused number 1, for instance, says when he went to sign the confession or statements before Maboto, I think, Maboto never even sat down. When Maboto came, they were assaulting him. All that group of policemen. And Maboto then called him aside and said, hey, you know what? Why don't you sign this document? These guys are going to injure you. And then, to save his life, accused number 1 says he signed. No discussion with Maboto in an office sitting down, according to accused number 1. Accused number 2 also says when he went to sign the alleged confession or statement before Mrs. Kronje, all he said when he got in, even before Mrs. Kronje could introduce herself as a magistrate, he came in and told Mrs. Matlaping, the interpreter, that may you tell the lady please that 6 weeks I haven't had a bath, from the 16th of June, I think. And also that I want to speak to my daughter, I want to speak to my partner or parents. And that was it. And he sat down and looked at the ground. And Mrs. Kronje, what he did was he was busy with his computer. She never asked him anything. All she was interested in was the computer, and then she would get out and gossip with a fellow magistrate or fellow white lady and come back. Mohonu was going in and out, consulting with Mrs. Kronje. Nothing was discussed between accused number 2 and Mrs. Kronje, except, as I said, that I haven't had a bath and I want to speak to my daughter and my partner. Nothing. The same applies for Rapudu. Accused number 2 says, no discussion with Rapudu, nothing. He was just beaten up and told to sign. So in the main, that is the salient aspects of the evidence relating to the trial within a trial. It's obvious that Keninda, Maholewa, and others gave evidence. But what I want us to understand is that this court, after careful analysis of the evidence adduced by the state, and after careful analysis of the cross-examination interposed by the defense against the evidence adduced by the state, and after careful analysis of the rebuttal evidence of accused number 1 and 2, and the cross-examination interposed by the state, and after careful analysis of the heads of argument by all the parties concerned, and the verbal submissions made by all the counsel in this court, I have dealt, not like this magistrate did, I've dealt with all the evidence relating to whether the said alleged confessions were made freely and voluntarily in the sound and sober senses of the deponents without any force or coercion. I've dealt with all that, and I've also dealt with the other primary defense by the accused, that all the accused were not apprised of their constitutional rights, meaning section 35(5) of their rights. They were never apprised according to that. And this court even also interrogated that. And as we all know, section 35 encapsulates the concept that if any evidence is acquired through the infringement of the Bill of Rights, that evidence should not be admitted into the record of the proceedings relating to section 1(7) and section 1(8), even section 1(9) of the Criminal Procedure Act. Right. Consequently, after going through all that evidence carefully, this court has reached the following conclusion. One, it rules that the confession made by accused number 1 was made freely and voluntarily without any coercion when accused number 1 was in his firm, sound, and sober senses. 2, the confession made by accused number 2 in respect of the said confession being taken by Mrs. Ronje, the magistrate, the court rules that it was made freely and voluntarily without any coercion when accused number 2 was in his full and sober senses. And also the confession made before Colonel Rapudi was also made by accused number 1, 2. Freely and voluntarily without any coercion when he was in his sound and sober senses. And also the pointing outs made by accused number 2 before Colonel Khadebe were also made freely and voluntarily without any coercion when accused number 2 was in his full and sober senses. Okay. That is the ruling.